A former Amazon employee is suing the online retailer, claiming she was wrongfully dismissed after dealing with long COVID. Brittany Hope says she was hospitalized in February 2020 and later realized she had been dealing with lingering symptoms of long COVID. The 29-year-old claims that when she applied for medical leave a few months later, that Amazon cut her off and her access to company email and the disability portal. 2 months later, she says she was fired for, quote, job abandonment and billed more than $12,000 for alleged overpayments of wages. Now, employment lawyer Alex Lucifero joins us. Alex, this situation, it's in the U.S. where it can be slightly different, but what options does an employee have if they're not able to work for medical reasons? What happens in that scenario?
Yeah, so this is an area of the law where actually our laws in Ontario are quite protective of employees. Employers have to be very, very cautious when dealing with employees who have medical disabilities or take medical leaves of absence. Employees have the following options. Number one is to actually take a medical leave. If your doctor is authorizing you to take a leave of absence from work for health reasons, as long as you provide your doctor with a doctor's note, and it could be a very basic doctor's note, you as an employee are allowed to take that medical leave of absence. Your employer cannot punish you for taking such a leave. The other right that you have as an employee is you are allowed as a right have the right to be accommodated in the workplace. So if you have particular restrictions as to what you can and can't do in the workplace, your employer has to accommodate you in that respect. Again, you cannot be punished or terminated for requiring accommodation for medical reasons in the workplace.
Okay, and let me ask you this follow-up. Is there a specific amount of time that you can be on a medical leave in Ontario?
It's a question we get very often. And I mean, the reality is there's no set time limit. And certainly, if you're having to take a medical leave of absence, that leave can be weeks or months. It can even be years. I mean, it could be several years, as long as there is a reasonable expectation that you will be able to return back to work as an employee. Your employer has to respect that medical leave. Of course, the employer has to make do in the meantime, perhaps replacing you as an employee with someone else, or making other arrangements in the workplace. But again, that medical leave has to be respected. And moreover, once you are cleared to return back to work, you have the right to return to your same position, the same terms of employment that you left when you went off on leave.
Okay, let me ask you this then. So we know that the employer, you're saying, has to let you take that leave. What if they say, no, I refuse? Where do you go from there? Who are the people that you talk to?
Again, employers have to be very, very cautious in these kinds of situations. You effectively can't say no. Again, provided the employee has provided medical evidence, again, in the form of a doctor's note, you cannot refuse a medical leave of absence as an employer. If you do, you are effectively in hot water. That can be considered discrimination under the Human Rights Code in Ontario. It's effectively discrimination on the basis of disability. An employee would be owed damages as a result of discrimination like that. You would also owe that employee severance. It's effectively a termination if you are not authorizing an employee to take a medical leave of absence. And so that employee would also be owed severance in addition to any human rights damages that they would be owed.
All right, Alex, thanks for taking the time today. Once again, that's Alex Lucifero, employment lawyer. Thank you.